Welcome to the Republican Professor Podcast. I'm your host, Dr. Lucas J. Mather. We're here in Brea, and I'm outside again. Got the waterfall going. That might be what you hear in the background. We're back in Duncan versus Bonta on Banc. March 20th, 2025. VanDyke's Dissent. Remember, VanDyke is a Republican appointee appointed by President Trump and confirmed by the Republican United States Senate. Because we're such fans of this dissent, we got an Oliva O, and this was donated by a TRP supporter. TRP means the Republican Professor. And this lighter was donated by a TRP supporter, a different one. So thank you. Thank you for this lighter. And the person gave me, the man who gave me, he's a prominent business owner in Southern California, very prominent manufacturer. I'm not going to say his name, but he gave me this along with a church warden pipe, and it really meant a lot to me, especially after the trials I've been dealing with the administration of this church. As the church warden, it's nice to feel seen, because in church administration you oftentimes do really difficult work that involves disciplining people older than you, which is a real hoot. It's a real hoot, but I really appreciate this gift of feeling seen, and to make it even more meaningful, it was given to me at the church. And then this Oliva Series O is just a beautiful cigar. I think it's a torpedo. I think that's what you call it. And the texture on this is just real amazing. It's like a leather chair or something. I think I've mentioned that kind of description before. So I'm going to light it up right here. And we got Writer's Tears again, Irish whiskey. It's a beautiful day in SoCal today, so we're going to go ahead and light it up. And it's not working. You know what? I might not have... It just worked like a second ago. I'm not sure if I'm doing it wrong or if it just needs new fluid. I'm going to pause this just in case it needs new fluid, because I don't want to embarrass my friend.
Recording in progress.
See that flame? Look at that flame. This is a man's lighter. Damn. Nice job. Nicely done. It's a little bit windy for that kind of a lighter, so I'm going to go to the torch, but I just want to let you know. Thank you for the gift. Writer's Tears also supplied by TRP supporters. They're not paid sponsors. We have no paid sponsors. We have people just that believe in the mission, and we're grateful for that. Okay, so let's get to it. My initial impressions are I did a V cut of this. I'm not sure if you're supposed to do a V cut for a torpedo. The draw is a little bit difficult, but overall I give it a pleasant rating. Now let's get into the case, okay? I'm going to pull it up. share my screen. Feel free to call me Sharon. Okay, I'm getting this from the Ninth Circuit's website, and the address is there. It will be linked in the description. We're on page 131. Let's go there now. We're in Roman numeral 2. The majority's analytical flaws do not end at the first step of its analysis, says VanDyke. Yeah. Tell us how you really feel, Judge VanDyke. Despite initially and incorrectly determining that large capacity magazines are not part of the arms covered by the Second Amendment at all, the majority proceeds to assess whether a ban on large capacity magazines is consistent with history and tradition. Judge Bumate aptly explains how the majority's analysis errs as a historical matter. I will elaborate on just a few points. Now remember, he's already done a video dissent, which is unique. I've never seen that done before. I mean, a video? Really? With guns in the video? That's what he did in his chambers in a federal courthouse. I might have to change this V cut to a regular cut because the draw is a little bit tough on this one. Is that normally how it is on torpedoes? I don't know. Once you get it going, I guess it's pretty good. I don't know. Maybe it's just the type of shape it is. Maybe that's part of the design. Okay, let's keep going. The majority explains that for cases implicating unprecedented societal concerns or dramatic technological changes, we should apply a more nuanced approach. It is true that the Supreme Court explained that some societal changes would be so unprecedented and some technological changes so great, we're on page 132 at the top, that historical regulations would not have contemplated them. In those cases, courts should reason by analogy. But rather than look for close analogs that impose a comparable burden on the right of armed self-defense that is comparatively justified, the majority warms up by opining that analogs should be flexible. What the majority's new flexible and nuanced approach devolves into is that the government need only show the sloppiest of fit between the historical example and the modern regulation. To show you what I mean, consider the majority's use of gunpowder storage laws as an example of a historical regulation analogous to California's ban on magazines holding more than 10 rounds. Under Bruin, we must look to why gunpowder storage laws existed and how those regulations burdened the Second Amendment by requiring gunpowder to be stored in a special container or place in the home. Makes sense to me. let's go back. There's a pretty substantial footnote on the previous page. I think we maybe should look at that. Footnote 2. Here the majority determines that such an approach is justified. Remember, the majority he's talking about is the Democrats on the Ninth Circuit and Banc that upheld California's ban on so-called large capacity magazines, which are really standard capacity magazines. In doing so, holding that they're not an arm protected by the Second Amendment, whereas magazines that in the discretion on that day, in that hour the bill was passed, in their discretion only, of magazines holding 10 or less rounds were arms protected by the Second Amendment, which in effect means that the Second Amendment constitutional right is determined by a discretion of a bare majority of a legislature and the executive's willingness to sign that. Did you follow all that? If you didn't, rewind it. I know you're going to say rewind. What are you, in the 80s? Well, yeah, I'm in the 80s, dude. Okay. Footnote 2. Here, the majority determines that such an approach is justified because large capacity magazines, when attached to a semi-automatic firearm, represent a dramatic technological change because they fire with an accuracy, speed, and capacity that differ completely from the accuracy, speed, and capacity of firearms from earlier generations. The majority seems to recognize the truth that most of the dramatic technological jump since the founding is attributable to the automatic cycling mechanism, not the large capacity magazines at issue here. Presumably then, because that mechanism accounts for most of the dramatic change making modern firearms quote-unquote especially dangerous compared to the muzzleloaders of our forefathers, the unstated conclusion, and here we're on the bottom of page 132, that follows from the majority's misguided analysis is that a state could ban semi-automatic handguns altogether. Not bad. I'm glad I read that footnote out loud. I want you to see this. Start with the why. I'm back on page 132. As the majority acknowledges those laws existed to prevent fires and explosions from the storage of gunpowder, or by prohibiting what had proved to be an especially dangerous practice. Heller itself summarized these storage laws in a similar way. Okay. On page 133 now. So far, so good. But how do those laws look anything like the magazine ban at issue here? Good question. If that leap confuses you, you're in good company. To get from gunpowder storage laws to bans on magazines with more than 10 rounds, the majority must summarize the why as to prevent a specific infrequent type of harm to innocent persons, or they further summarize it to stop an especially dangerous use of firearms. Turning to the next step, the majority characterizes the how as completely prohibiting certain methods of storage. So, the majority generalizes the history and traditions test, first explicated in Bruin and then expanded upon in United States versus Rahimi, to the level of especially dangerous, and posits that the government can completely ban anything that fits that description. It is hard to imagine a degree of fit much sloppier than that. It's time to take some puffs on the cigar after that. My goodness. How are you guys doing? Still lit. I guess this cigar is on the varsity, not the JV. Nice job, Oliva. Drop a comment if you see any problems in VanDyke's analysis, or if you want to say, attaboy. Or if you don't care, don't drop a comment. And go upon your merry way. For me and my family, we care. If VanDyke is right, you should be deeply disturbed. Deeply. I think he is right. I think he's exactly right. Yeah. I think he's exactly right. Let's keep going. What do you say? Pick you up any time of day. By taking any historical example that completely bans a specific activity and raising the level of generality for the why to something akin to mere dangerousness, it is hard to see how any gun regulation wouldn't pass muster. Because governments have been banning dangerous stuffs and activities since time immemorial. Right? Right? Fin Act. In fact, I would venture to guess that even the regulations that failed in Heller or Bruin would survive such trifling scrutiny. What a, how convenient. How convenient for the Democrats. That's a convenient outcome right there. That is a convenient outcome right there. All right. After all, lots of historical laws have prohibited dangerous things, and even the jankiest firearm in the hands of the wrong person is especially dangerous. Here's another footnote. Okay. We don't need to get to that. So what stops we're on page 134 at the top, the government from banning the possession of all firearms under the majority's loose test? Okay. I'm getting a little bit sick of this V-cut, so I'm going to go ahead and I'm going to attempt a regular cut mid-stream here. I'm switching horses midstream. Way better, way better, way better. Yeah, okay, V-cut was the problem. Way better. Great. There we go. Okay. Great. Sharing my screen again. Feel free to call me. You guessed it. Sharon. All right. But that's not the only way the majority overhauls the Supreme Court's test. The majority goes on to candidly acknowledge that, in its view, every Second Amendment case involves dramatic technological changes. One can imagine now the reasoning our court will employ in the future to substantiate this pronouncement. Cases like Rahimi, with a focus on domestic violence, will come to stand for the proposition that all modern societal ills, even conceivably related to firearms, are dramatic societal changes, justifying the majority's sloppier, quote, more nuanced, unquote, approach. And any appreciable advance in firearms technology, whether that is the automatic cycling mechanism, higher ammunition capacity, better optics, an improved barrel, etc., will come to represent a dramatic technological change that the founders could not possibly have comprehended. The inevitable consequence, and presumably the intended effect, of such a rule is that circumstances will always be different enough to justify the more, quote, nuanced approach, unquote. And the more nuanced approach, quote unquote, will always justify ill-fitting comparators. What is the end effect of this scheme? Now let me point something out here. What is the end effect of this scheme? This is reductio ad absurdum. I've been beating that drum. Reductio ad absurdum. This reduces to absurdity. The end is absurdity. Now, in a reductio ad absurdum type of argument, whether inductive or deductive, and I know some of these logic freaks are going to be like, it's deductive only. Well, it depends on the language you're using. If you're only going for probability, then it's not deductive. The difference between deductive and inductive argumentation lies in the intention of the arguer only. That's it. If I argue modus tollens, but I put a probably at the end of in front of the conclusion, my intention is only for a probability. Now it turns out I have given the premises, I have 100% probability. But I might not know that. I might not be that smart. I might soften it and say probably. Well, 100% is probably. And this is a little bit of inside baseball on logic, but if you disagree with me, let me know. I mean, am I wrong? Maybe I'm wrong. Maybe. Okay. But I don't think I am. This is a reductio ad absurdum type of argument. He's saying this reduces to absurdity. Now, you could put this argument in a deductive form, a valid deductive form. You could. I mean, I could. But I'm not sure that that's his intention. I'm not sure. So I'm trying to be sensitive to what he's intending. I think what he's saying is likely this reduces to absurdity. And therefore we have a problem with the premises. We have a problem with what the majority, the Democrats, are assuming. It essentially writes Bruen out of the United States reports, at least out here in the Ninth Circuit. Notwithstanding Bruen's clear command, he's challenging his inner John MacArthur there. Scripture clearly teaches. I always wondered, if it's so clear, why do you have to say it? But, he is saying it. Notwithstanding Bruen's clear command, that the government will be held to its burden of showing a distinctly similar historical regulation to succeed in a Second Amendment case, the judges of this circuit will always find some reason or other to excuse the government from meeting that burden. Page 135. To summarize, we're on page 135 at the top. To summarize, the majority's test boils down to whether any new gun regulation was passed to deal with situations that are especially dangerous. Why especially dangerous as opposed to just dangerous? Especially dangerous is in quotation marks, FYI. Perhaps because the majority implicitly recognizes that merely dangerous, quote, dangerous, unquote, would be too obviously defiant. Dangerousness itself is clearly inherent in the definition of a weapon. Quote, an instrument used or designed to be used or to be used to injure or kill someone. That's weapon in Black's Law Dictionary, 12th edition, 2024. Yeah, getting the dictionaries out. Wow. Yeah, buddy. Judge Kavanaugh made the same comment, very similar comment, in the third series of the Federal Reporter, volume 670, 2011, in Dissent. And if you grab that volume off the law library shelf and you just look in the front part, you look from the front matter and you look for DC Circuit, you'll see Heller versus DC. It's Heller 2. Or DC versus Heller. I can't remember which one it is, but it's Heller 2. And at the time, Judge Kavanaugh is writing in Dissent. And he says, all weapons are dangerous. What are you talking about? That's the very idea of a weapon, you idiot. He even says, you idiot. No, I'm not. That's J.P. Moreland, my metaphysics professor. Idiot. Idiot. He's a guest on this podcast, by the way. See February 2022. Excellent episode. Okay. And because the very purpose of a weapon is to be dangerous to the criminal, right? To be dangerous to the immoral criminal trying to attack the innocent person. Of course you want to be dangerous to the criminal, to the thug, to the armed gang, to the whatever it is, right? The immoral criminal. The more dangerous a weapon is, whether because of concealability, stopping power, ease of use, rate of fire, or any number of other considerations, the better it is at doing what it was designed to do. Now, in my notes, I have dangerous to what? Yeah, see, that's a good point. And it's my point, so of course I think it's good. Dangerous to what? And I put criminals? Question mark. Dangerous to what? If it's dangerous to the enemy, good. Am I right? Okay, come on, you guys. Let's camp out on this point here. This is basic analysis. Dangerous to what? I mean, what kind of world are we living in here? There's just, there's no immorality, there's no crime. Well, in such a world, if something was dangerous, then I guess then that would be the end of the answer, right? But we don't live in a world that has no immorality and crime. There's rampant violent crime. So when you use the word like dangerous, you have to ask the question, dangerous to what? To the criminal trying to attack you and your family, trying to kidnap your daughter and rape her? Dangerous to that? Let's be clear about this. Why do the Democrats not want you to be clear about that? Why do they enjoy the obscurity about that question? Republicans don't enjoy that obscurity. It's Republicans asking that question. Dangerous to what? And by the way, the historical analogs they're relying on about disarming Indians, about disarming blacks who were enslaved, disarming freed blacks after the Republicans freed the slaves. You could ask the same question. Dangerous to what? The slave owners? Dangerous to the people trying to kill the Indians? This is what the Democrats are relying on. Just dangerous. Dangerous to what? Dangerous to what they want to do. Which is what? Leave certain groups of people undefended against crime. That's the answer. And Republicans are saying, no, not on our watch. No, thank you. Sorry, not going to play that game. Not going to play it. Let's continue with the text. The very purpose of a weapon is to be dangerous. The more dangerous a weapon is, whether because of concealability, stopping power, ease of use, rate of fire, or any number of other considerations, the better it is at doing what it was designed to do. A rule that allows a ban on all dangerous weapons could thus effectively be a ban on all weapons. Full stop. Except, if the government has them. Except for if the Democrats have them. The slave owners. The majority, and California, no, they cannot create a test that bans any firearm that anyone could perceive as dangerous because every firearm has the capacity to cause serious harm if used improperly or placed in the wrong hands. So instead, California points to its conclusion that large capacity magazines are uniquely dangerous, and the majority finds a historical underpinning for a ban on all weapons that are especially dangerous. Of course, the test for what qualifies as especially dangerous looks quite a lot like the majority's interest balancing test from the days of Duncan's past. To begin, the majority evaluates the how by explaining that California's law, we're on page 136 at the top, imposes only a minimal burden on a plaintiff interested in exercising his Second Amendment right, which sounds a lot like cut and paste of the first step of intermediate scrutiny. Compare Duncan 5. Duncan 5. That's how many times this has gone up and down. Wow. Duncan 5. Compare Duncan 5. By the way, this is a rare time you're going to see a typo. You see the typo? It's on the Ninth Circuit's website. You see the typo? Compare. Compare should not be italicized. Duncan 5 is italicized. Whoever was doing the italicization did a little bit too much italicization. That's funny. And then they included with. Compare Duncan 5 with the majority here. According to the majority, the burden on such an individual is only minimal because the law imposes no limit whatsoever on the number of magazines a person may own, the number of bullets a person may own, the number of firearms a person may own, the number of rounds a person may fire, or the number of firearms a person may fire. Judge Graber, in both the majority opinion and her concurrence, made that point last time too. Really? I'm going to have to take a look at that. Judge Graber? Really? See? Even I learned stuff. Why did I miss that before? I didn't even pay attention to that last time. I don't know why. I have a comment here in my printout. Sheds light on why interest balancing tests were created in the 2A context. Yeah, that's right. I agree. Okay. I'm going to chase down that Judge Graber thing next time. If you want to chase that down, I'd love to hear what you have to think about it. But, okay. And this is back to VanDyke. And I already pointed out that is unrealistic. The majority also again emphasizes that firing more than 10 rounds occurs only rarely, if ever, in armed self-defense. My colleagues made the same argument last time, and I explained then why it doesn't hold water. Nevertheless, as before, the majority concludes that the large capacity magazine ban is minimally burdensome because it only prohibits one specific and rare use of semi-automatic firearms. And then there's one error I have to correct here. Okay. Stay with me here. It's in one of the parentheses, and I don't normally read the parentheses. It says, and here's the majority opinion he's quoting, the ban on large capacity magazines has the sole practical effect of requiring shooters to pause for a few seconds after firing 10 bullets. What's the problem with that? What's the problem with that? It's a factual problem. Anybody know? Tell me in the comments. Tell me in the comments. That's right. You can have one in the chamber. 10 in the magazine, one in the chamber. So 11 bullets. See, this is what people do when they don't know what they're talking about. All right. 137. Here we go. Next, the majority goes on to evaluate the why, determining that California's law is similar to its historical analogs because mass shootings are devastating for the entire community and large capacity magazines exacerbate the harm. This again looks quite a lot like the discredited intermediate scrutiny test that the majority applied the last time around. Because California's law seeks to prevent or mitigate devastating harm to innocent persons due to especially dangerous use of weapons, California's law must be justified. Is it just me? Is it just me, or do we seem to be right back where we were before Bruin? Except somehow worse. That's exactly right. Except worse. That's exactly right. Pay close attention to what he just said. Burn this into your memory. Sear it into your skull. Tattoo it on the inside of your eyelids so that you can study it when you go to sleep at night. Except somehow worse. In important ways, the majority's lax historical balancing test is even easier for the government to satisfy than intermediate scrutiny. Yes. Yes. Here, the majority discusses the burden on an individual's right to self-defense, just like it did in Duncan 5. But if the majority can already point to a historical analog of a complete ban on a weapon, why does it need to show a minimal burden at all? Really? So long as it has a matching Y, and there will always be a matching Y, because the inherent dangerousness of firearms will always match the majority's permissive, especially dangerous level of generality, any new law could similarly burden the individual's right to self-defense in the same way as any ban at the founding. More glaringly, when considering whether the risk of harm is justified, the majority weighs everything in favor of the government and ignores the always corresponding burden that the ban imposes on law-abiding citizens. This is absolutely key. Absolutely key. Sear that into your brain right now. Look at it. He's absolutely correct. I'm going to have you look at that for a while. Tell me if he's incorrect. I don't see how he's incorrect on this. Like every part of a firearm, large capacity magazines are of course especially dangerous, quote unquote, in the hands of a criminal. So is having a semi-automatic instead of a single shot handgun. And so is having good sights that help the criminal hit what he's aiming at. Page 138 at the top. On the other hand, not having good sights decreases usefulness for law-abiding citizens. Yes, and so does having a lower capacity magazine and being forced to reload when put in a lawful self-defense situation. Take the majority's thrice repeated line, quote, "The short pauses when a shooter must reload a firearm afford intended victims and law enforcement officers a precious opportunity to flee, take cover, and fight back." What's the problem with this quotation right now? Now, before we pause, I'm not saying VanDyke has I'm not saying this is a problem with VanDyke's analysis. I'm saying this is the majority's thrice repeated line. See this one right here. A shooter. I want you to focus on this word, a shooter. You'll see this word used a lot. Active shooting, a shooter. I think the meaning behind the intention of the speaker when it's a Democrat is an immoral person, right? But if you take a look at that word, shooter, does it imply immorality analytically? No, it does not. Why do I know that? Because shootings happen every day lawfully and legally at gun ranges. Every time a gun goes off, it's shooting. And the person doing it is a shooter. That's true in recreational shooting. It's true in hunting. It's true in self-defense. It's true in all lawful cases of shooting. The person doing it is a shooter. Take a look at the rest of this quotation. The short pauses when a shooter, we've already seen how that's a problematic phrase, must reload a firearm, afford intended victims and law enforcement officers a precious opportunity to flee, take cover, and, fight back. Wait, hold on a second. Fight back. What would that look like? Hold on a second. Fight back. What does fight back look like? Doesn't it involve shooting? And wouldn't that mean that the subject of that verb is a shooter? Which you just implied was the criminality at issue here? You ever notice that gun violence statistics never include law enforcement? Law enforcement always use gun violence. Always. Because even the threat of gun violence is gun violence. Just having it on your hip, ready to go, is implicit gun violence. That's why I don't like the term gun violence. And I've said this a million times. The word shooter, active shooting, these are problematic terms. Ditch them. They do not imply anything as regards to morality, anything at all, or legality. There's all sorts of problems here. But what of armed victims attempting to defend themselves and others? Very good. Very good. Very good. Excellent job. They too must pause to reload. See, they too are shooters. Let me use a different example. Let's say he said the word puncher. Punchers. That would imply you can't punch back. Wrestlers. That would imply you can't wrestle back. It's not that hard, guys. I mean, just think about it. Think logically, for God's sake. Come on. Come on. But what of armed victims attempting to defend themselves and others? Exactly. Very good. They too must pause to reload, and their pauses give assailants time to get off more shots, not to mention the greater potential for malfunction with every magazine swap. And that is only if the victim happens to be carrying an extra magazine in a place where she can quickly get to it. Pauses in shooting, notice, problem of that term, don't just mean a chance for victims to take cover. Pauses in shooting while trying to reload also mean a chance for victims to be overwhelmed by criminal assailants. It always works both ways. Exactly. He hit the nail on the head. What he's trying to say is that the Democrats are systematically ignoring the weak person, the vulnerable person, the slave, the Indian, the criminal, the victim of criminality, attempting to fight back. This is the Democrat way. It's sad. Republicans are here to help, though. Here we go. Yet the majority sees only a one-way street. That's exactly right. They only see the more powerful people, claiming that the need to reload in a self-defense situation seldom occurs. We've been down this road before too. Statistically, mass shootings, see again, that term shootings is very problematic. It should be mass murder or mass attempted murders. Almost never occur either. But for the majority, extremely rare criminal acts count against the Second Amendment, while similarly rare self-defense needs are irrelevant. Well said. The majority's assumption that the need to reload in a self-defense situation almost never happens in real life may not be as justified as it thinks, though I'm on page 139 at the top, and becomes even less so in a modern society increasingly plagued by unchecked group violence. There is at least one disturbing example from right here in the Ninth Circuit, indeed not far from where we heard oral arguments in this case. In October 2021, retired police captain Ursi Joyner was pumping gas in Oakland when a group of assailants attempted to rob him at gunpoint in broad daylight. The assailants pointed their guns and repeatedly told each other to shoot Joyner, even as he complied with all their demands. Joyner was carrying a Glock 43 and eventually made the choice to defend himself. He fired at the assailants and they returned fire. Joyner fired 10 times, emptying his magazine. Now I want to say something. If you don't know anything about the Glock 43, it's a small firearm. It's for concealed carry, so it has a small capacity by design. Joyner fired 10 times. He can be seen on the gas station security footage having to then take cover and pretend to shoot back while the assailants continued to shoot him at close range before finally driving away. Remarkably, Joyner survived, but he was shot multiple times before the assailants fled, leaving 22 bullet holes in his body. Again, that is just one anecdote, and I don't dispute that these situations are uncommon. I think it would be worth having a look at footnote 6. Indeed, as I've emphasized before, all self-defense uses of firearms are relatively uncommon. So the uncommonness of the need to use a firearm for self-defense cannot be a reason to deny the Second Amendment's protections. But as I explained in my previous Duncan en banc dissent, so are all instances where individuals need to actually fire a gun to defend themselves, including against mass shootings, which form the majority's and California's shared rationale for these bans. As I stated then, the standard cannot be based on the practical infrequency of any particular person's need to actually defend herself with a gun, or on the practical infrequency of her need to use multiple rounds to do so. We shouldn't be balancing the Second Amendment at all, but if the majority can't help itself, it should at least stop loading the scales. Watering down the history and tradition test the way the majority does here creates real consequences for real people exercising their Second Amendment rights. And we're in Roman numeral 3 on the next time, and I want to just hang out with you guys and have a cigar and ask you what you think about what was just said. And I want you to really think about it. I'm still here. I'm using the church warden lighter here. Well, what do you think? Is VanDyke right? Or is he wrong? I think he's right. Thank you for joining me on the Republican Professor podcast. I've been your host, Dr. Lucas J. Mather. Today is Sunday, 10 August, 2025, years after. Jesus, I'm coming to you from my mentor's house. This is not my house. It's not my waterfall. It's not my pool. It's his. He's my epistemology professor and mentor. Great, excellent scholar, tremendous value. I got so much value out of studying epistemology with Dr. Doug Guyvet, who's a guest on this podcast. I TA'd for him for apologetics at the undergraduate level at Biola. Also TA'd for TRP guest David Chalky for logic. Their wonderful experience. He also taught philosophy of religion. And we had the guest professor from Oxford, Richard Swinburne, out. Wonderful little hobbit there from Oxfordshire, the Mercian kingdom, Anglo-Saxon Mercian kingdom of Oxfordshire. The little hobbit taught us. He's never going to see this, so I'm not worried. The little hobbit, Richard Swinburne, taught us philosophy of religion. Is a wonderful little book he wrote with Oxford University Press called Is There a God? Excellent, excellent, excellent. The religious epistemology that we got there was so good. And like I said, I'm going through Dallas Willard's Ontology of Knowledge that I found in Doug's office from Biola University, summer 1997. Excellent. I'm enjoying it so much. I was so sad to see June 3rd's tape 1 blank. Someone taped over it or didn't hit record or something. I don't know. Tape 2 played, and that's the only hiccup I've seen so far, but it was excellent. You had Tom Cripps. You had, I think Tim Mosteller was there. Maybe Dan Yim. I think I heard his name. Or not his name, but I think I heard his voice. I might be wrong. Maybe Steve Porter was there. I don't know. Who else was there? Greg Tanalsoff was there. He taught my 20th century analytic philosophy, history of analytic philosophy. By the way, Scott Soames' 2-volume History of Analytic Philosophy, excellent. I read the whole thing carefully, excellent. And that was after I took the class from Greg. Scott Soames teaches at USC. He's a Republican. Oh man, that is so awesome. And he did such a great job on that 2-volume set. It was so helpful for me. If you want to know more about the history of analytic philosophy, Scott Soames' History of Analytic Philosophy, Volume 1 and 2, excellent. But Dallas Willard on the ontology of on the ontology of knowledge was so good. I mean, I heard J.P. Moreland, a guest on this podcast, Doug Guyvet, a guest on this podcast, asking questions. And it was the first time I heard my professors asking questions as if they were a student, and they were his student. And it was just like we heard in our classes when they were our professors, except for when they were the student asking their professor. And it was just so meta. It was awesome. It's so awesome. It's such a great thing. I'm so grateful for this opportunity this summer to be thinking about that stuff. So I'm having a great time with this Oliva. This Oliva O is holding up. Just so you know, with the torpedo cuts, the torpedo shape, you don't want the V cut. And the writer's tears doesn't disappoint. Thanks to my TRP supporters. We'll see you guys later.